I'm for the defendant, my lord.
Lordship, I appear for the plaintiffs in this matter.
Yes.
Lordship, I'm led by Mr. Joydeep Kaur. He is on his way. Your Lordship, may kindly give me a short passover.
This item 29.
Item number 29.
So which application was being heard? GA
Lordship, the application was filed by the defendant.
Well, I'm for the dependent petitioner, my lord.
The defendant has filed this
Last week
application.
I started, my lord. If they have any problem, my lord, they can pray for adjournment today, my lord.
Application, Your Lordship, has been filed for recalling of the decree, the consent decree.
Yes.
Lordship, insofar as the
So
application is
the
concerned,
applicant has not concluded.
No, my lord. I have just started, my lord. On the last
Let
occasion,
him-
I
he can
started, my
continue.
lord.
You continue.
So, my lord, I'm starting, my lord, because
Yes, yes.
my lord, kindly consider page 36 of my application, my lord, the order which I have prayed for recalling, my lord. 8 September 2015, my lord. Page 36 of my application, my lord. Annexure E. May I read, my lord?
Yes, 36.
Yes, my lord. Annexure E, my lord. This is the imperial order, my lord. And we prayed for recalling of that very particularly 8 September 2015, my lord.
Yes.
This is a partition suit in respect of the properties belonging to the estate of late D.N. Das. The plaintiff number is the one is the eldest son. The plaintiff number 2 is the daughter, and the defendant is the younger son of late D.N. Das. So the suit is in between the brothers and sister, my lord. One brother and one sister, being the plaintiffs, have filed the suit, my lord, against the another brother. He is the defendant, and that defendant is being the petitioner before your lordship, my lord. During the pendency of the suit, the parties settled their dispute except in respect of the immovable property, residential property situated at 77 F Korea Road, Kolkata 7,19,000. This court passed a decree on 13th March 2015 in accordance with the terms of settlement by the parties. So earlier occasions, my lord, another terms of settlement was filed. That was filed on 13th March 2015. Today it is submitted on behalf of the parties that they have also settled their disputes in respect of the aforesaid immovable residential property. Terms of settlement have been filed in court, duly signed by the parties. Duly signed by the parties, not duly signed by the learned advocate on records of the parties. There does not seem to be anything unlawful in the terms of settlement. Under those circumstances, the suit is decreed on the basis of the terms of settlement arrived at between the parties on 29th August 2015 in respect of the remainder of the subject matter of the suit. Accordingly, the suit is disposed of. So, my lord, there are two settlements. On 13th March, first settlement was signed. Second settlement was signed on 29th August, and that is being, my lord, comes into an order.
13th March 2015, there is no dispute.
No dispute at all, because, my lord, rest of the properties and other
Okay,
disputes have
29th
already been
March
amicably settled.
2015, there is a second settlement.
29th
Okay.
August.
Yes,
Yes.
29th August.
Okay, when did you file this into application?
My lord, I have filed this
2016.
application on, my lord.
Yes, 25/4,
Yes, my lord.
2016.
After knowing the entire episodes of facts, my lord, I filed the application for recalling of that very particular order because, my lord, according to me, my lord, the terms of settlement as allegedly has been filed before the honorable court has not been consented with my own will and volition, my lord. Because whatever the signed as has been obtained by the plaintiffs, my lord, that has fraudulently obtained from me, my lord. And I have explained the facts, my lord, in the application, my lord. My lord, paragraph 13, my lord. From paragraph 13, my lord, I have explained. under what circumstances they have procured my signature, and on the basis of that fraudulent signatures, they have prepared the terms of settlement. And then thereafter, my lord, they have filed the terms of settlement before the honorable court, my lord. On the basis of that, the decree obtained, my lord. And after knowing the facts, my lord, I filed the instant application for recalling of that very particular decree, my lord. My lord, paragraph 13, my lord, what I have stated in the application, my lord, your petitioner states that your petitioner never instructed anybody to represent your petitioner before his lordship, the Honorable Justice Arijit Banerjee.
No,
or
who was holding power on behalf of your client at that point of time?
at that point of time, my lord, my advocate on record was Joydev Ghodai.
Yes,
Joydev Ghodai did not appear on that very particular day, my lord.
Very well. He was holding power.
Yes, my lord. On behalf of me, I was appointed Mr. Joydev Ghodai as my advocate on record, my lord.
Very well. So let us see.
On first settlement, my lord, parties and their learned advocates
Question
put
is-
their
question
signatures,
is-
my lord.
So this advocate was holding power on your behalf. So when the final order was passed, he was not present.
He was not present. He did not put his signature, my lord. Even, my lord, that advocate on record filed the instant application for recalling of the order,
Question is, you see,
my lord.
this the appearance is only two learned advocates.
Yes, my lord.
That is for on behalf of the plaintiffs only.
No, my lord. According to them, my lord, Aryak Datta appeared on behalf of the defendant. But according to me, my lord, and as per my instruction,
Who
my
was
lord,
holding power on behalf of Aryak Datto?
Aryak Datta being the counsel appeared.
No, who was holding power on behalf of the defendant?
Defendant, Joydev Ghodai, my lord.
Joydev Ghodai.
Ghodai.
Did Mr. Aryak Datto appear on the earlier occasions?
Yes, my lord. It is recorded from the order
Earlier
sheet.
occasions he appeared.
But according to me, my lord,
On 10
I-
occasions. Yes.
No. Question is, you see, this Aryak Datto definitely was engaged by the advocate on record to appear. So
my lord,
earlier occasions he appeared.
in that circumstances, my lord, advocate on record should depose before this honorable court that I myself instructed to brief Mr. Aryak Datto, or advocate on record should disclose before your lordship that Aryak Datto.
Question is, so far, you see, learned advocate on record is concerned, he was not present. Only the senior is present.
No, my lord, according to me, my lord, none was present at that point
So
of time.
have you stated the appearance of Mr. Aryak Datto is without any authority?
Yes, my lord. Yes,
By
my lord. I have stated in
which
my
paragraph
application.
you have
Yes, my lord. I am coming, my lord.
No, you show me that paragraph.
My lord,
That
paragraph 13.
appearance of Mr. Aryak Datto is without any authority.
My lord,
That is
kindly consider paragraph 13, my lord.
paragraph
Once again,
13.
paragraph 13 of my application. I once again, my lord, reading for my satisfaction, my lord, your petitioner said that your petitioner never instructed anybody to represent your petitioner before his lordship, the Honorable Justice Arijit Banerjee, on 26 August 2015. From the order dated 26 August 2015, your petitioner was surprised
How
to find.
petitioner can never be briefed. You see, their counsel is always briefed by the advocate on record.
Yes, my lord.
Okay.
That is my coming, my lord.
Your petitioner has been informed by his advocate on record.
I am coming there. From the order dated 26 August 2015, your petitioner was surprised to find that on that occasion, your petitioner was represented by a counsel whom your petitioner had never briefed. Your petitioner has also been informed by his advocate on record that he also never briefed any counsel to appear on behalf of your petitioner. My paragraph 13, my lord, I have clearly stated on affidavit. Myself has not been briefed. My advocate on record has not been briefed, Mr. Aryak Datto.
His suit is pending, okay? Separately, nothing is to be briefed. The advocate, when he is holding power, he
Yes,
is
my
to
lord.
appear.
So, my lord, advocate on record has also not been briefed, Mr. Datto.
Okay.
As far as your petitioner has been able to ascertain
so-
the counsel, paragraph 13, kindly consider paragraph 13, my lord,
So
four sentences, my lord.
this is drafted by
Drafted by my lord.
the advocate.
My advocate on record, Joydev, same advocate on record, Joydev Ghodai.
Joydev Ghodai has drafted this petition.
Yeah, my lord. On 26 August 2015, he was also the advocate on record. At the time of filing of the instant application, he was the advocate on record. He himself has put the signature on the petition, my lord. So whatever the contents that has been written in this application is true to the best of the knowledge of the advocate on record, my lord.
Yes. What is their opposition
My
letter
lord, may I? Yes.
with
And
paragraph
my lord,
15?
Yes. Kindly have a look at the opposition.
No, let me see. In opposition of paragraph
yes,
13.
my lord. Yes, my lord.
Let us see what is the.
Because I have not completed, my lord.
You have dealt with the this
Yes.
paragraph.
Yes. kindly takes a look at my lord, page 28, paragraph 42. I've given the details of the exact dates when this learned counsel has appeared. And this is not only a
No, let me see paragraph 13.
paragraph
Your opposition in paragraph 13.
13. To
Yes,
that, I have
legal
dealt
the
with
thing.
in paragraph 42. This is my opposition, paragraph 42, dealing with paragraph 13. This is a perjury, my lord, if I may say.
Page 28.
Page 28 kindly takes a look at paragraph 42,
28.
28 of my affidavit.
Yes.
The contents of paragraph 13 of the instant petition are false, frivolous, and mischievous. I say that the defendant has been represented by the said counsel since the beginning of the matter. The said counsel had represented the defendant in the following forums: before the Joint Commissioner of Partition on 4/12/2012, before the Honorable Court on 12/12/2012, before the Joint Commissioner of Partition on 14/1/2013, letter dated such and such before the Joint Commissioner of Partition, before this Honorable Court on such and such, then again before this Honorable Court on 27th August 2013, along with the advocate on record, before this Honorable Court on 10th September 2013, along with the advocate on record, before this Honorable Court on 2015, although the name of the defendant's counsel is not recorded in the said order.
Defendant's counsel is there, but the advocate on record's name is not there.
Not there. Very well.
Okay.
So when it happens on various occasions that we get a back sheet from the solicitor to appear. But it is never the practice, and especially in these days,
No,
that
because the
every day there has to be a fresh.
learned advocate who has stated, okay,
Yes,
that he has not instructed the counsel. Here it is prepared in his office.
Yes,
Okay, this petition.
maybe, but your lordship would see from all these previous instances that he was the one. Kindly see from page 61 onwards. Page 61 onwards, I've annexed all these. On each and every occasion, my lord, it's not a one-off incident. I could have understood it's a one-off incident that somebody is not authorized to appear. He had been appearing all along.
His only question is, you see, the advocate who has prepared this, it is within his knowledge that he has not instructed the counsel to appear.
That I am saying it cannot be because of the surrounding facts. Your lordship would take from page 61. It cannot be. Your lordship will not believe that statement because page 61 onwards. Kindly seize all these orders. This is one, which is, my lord, the
No, other orders they are not disputing. Only on these
but
orders they are disputing.
then if these kind of defenses are taken and your lordship permits these kind of defenses to be taken
and you
and
see,
sustained, then anybody would say on that date I did not instruct. We do not receive any instruction.
it is not the only litigant who has not saying that instruct. It is the advocate on record who is supporting this case. That is the thing.
No, that cannot be the case. Kindly seize the paragraph at page 13 once. Paragraph 13 once. That perhaps cannot be the case. Why I say so? Kindly permits me to place that paragraph.
Yes.
The third line. From the order dated 26th August 2015, your petitioner was surprised to find that on that occasion, your petitioner was represented by a counsel whom your petitioner had never briefed. This is perjury, whom the petitioner had never briefed. I have given 8 instances where that particular counsel was there. So this pleading that it is never briefed is on the face of it deliberate false statement. Kindly reads on. Your petitioner has also been informed by his advocate on record that he has never briefed any counsel to appear on matter on your behalf of the petitioner. Again, false statement. Absolutely false statements, man. And the fact that the statements are false would be evident from each and every occasion where even before the meetings, before the Joint Commissioner of Partition, he was present.
Yes,
So the statements that he was never briefed.
No, where is the meeting of the Joint Partition
Yes,
Commissioners?
kindly comes to page 76 of my affidavit. Annexure H, page 76. Kindly sees the persons who had appeared.
And it's page 76.
Kindly see serial number 3.
Oh, this is 2012.
So the pleading is never briefed. That is the pleading. That he has never briefed this council.
That is all.
So the starting point. Kindly see.
Prior to this 2015, any meeting was held.
2012.
But I have annexed all documents. Kindly see page 79. This is 2013.
Yes.
78 a court's order.
78 is court's order, where his name appears. Then, my lord, will kindly take a look at page 83. Page 83, joint partition commissioner's rights to this learned advocate, my lord, gives the notice to for this. Never doubted at any prior.
Anyway, so now let him complete. I just obtained the clarification.
Yes. And my lord, here your lordship would find till the end of this affidavit all the orders where he has appeared.
Anyway, you conclude.
My lord, once again, my lord, I am showing the impugned order, my lord. My lord, page 36, once again, my lord, I am reading. This court passed a decree on 13th March 2015. Prior to that, what my learned friend is showing, my lord, prior to 13th March 2015. So, one terms of settlement, filed. One terms of, after filing of the terms of settlement, the suit was continuing on. Thereafter, my lord, until unless, my lord, my advocate on record asks the learned counsel to appear on behalf of the defendant party, the learned counsel cannot appear. My advocate on record clearly stated in paragraph 13, my lord, none the party or the learned advocate on record briefed the counsel, my lord. I kindly come at paragraph 13, my lord, of my application, my lord. Your petitioner has also been informed by his advocate on record. My advocate on record informed the petitioner, my lord, that he also never briefed any counsel to appear on behalf of a, never mean on that very particular day. No. Never mean prior to not 13 March 2015, my lord. As far as your petitioner has been so ascertained, the counsel who allegedly presented your petitioner on 26 August 2015.
Yes, yes, that is your on 13. Yes, any other paragraph?
Any paragraph, my lord. Under what circumstances, my lord, they have procured my signature, that also to be considered by your honor, by your lordship, my lord. Kindly consider paragraph 14, my lord.
Yes.
Very next paragraph, your petitioner states that the parties herein, along with their cousins, were the joint owners of a property situated at Ramkrishnapur, Howrah. For quite some time, the parties herein and their cousins were trying to dispose of the said Howrah property for their mutual benefit. However, in spite of efforts, no suitable purchaser could be obtained for the said Howrah property. One of the reasons for not being able to find a suitable purchaser for the said property was the said property was last recorded in the name of Dr. Pramodnath Das, since this is being the great grandfather of your petitioner. Thereafter, my lord, in or about the 3rd week of August 2015, the said plaintiff number 1 informed your petitioner that after much persuasion, he has also been able to convince an intending purchaser to purchase the said Howrah property on as is various basis. On that occasion, the plaintiff number 1 further informed your petitioner that the said intending purchaser is desirous of purchasing the said Howrah property at an early date, and he has expressed his desire to complete his conveyance on 26 August 2015 upon payment of the entire consideration. Thereafter, my lord, what I have stated, it is the original fact, my lord, that on 28 August 2015, the parties herein and their cousins, being the joint owners of the said Howrah property, had assembled at the said family dwelling house of the parties herein situated at 77F Korea Road, Kolkata 19 at about 1 p.m. for execution of the requisite deed of conveyance. Though the intending purchaser was also present along with the entire agreed consideration amount payable to each of the co-owners by check, yet the plaintiff number 1 had raised objection in receiving such consideration by check, and as such, the conveyance was not executed on 26 August 2015. So on 29th August, 28th August, what has happened, my lord, I have explained. On that occasion, all the parties present there had agreed to reassemble at the said family dwelling house on 29th August 2015 in or about same time. So on the very next day, the program schedule that on 29th August 2015 in the morning, your petitioner had to go out for attending some of his personal works. When your petitioner has returned to the said family dwelling house at about 1 p.m., everybody else had reached the said premises by then. On seeing your petitioner, the plaintiff number 1 had in fact expressed his dissatisfaction on your petitioner not being there in time and informed your petitioner that everybody else had signed the deed of conveyance along with other requisite documents. So, not only that the deed of conveyance was signed, other documents were also signed. And papers which were required not only for transferring the said property but also for mutating the names of the party and particularly the name of the purchaser in place and state of the name of the great grandfather of the parties herein. Your petitioner accordingly signed all the papers and documents which were produced before your petitioner by the plaintiff number 1 in a hurry without verifying the contents thereof. So whatever required documents they actually required also are taken into consideration for signature. In additionally, they have also procured certain papers, my lord. Immediately after your petitioner had put his signature, the register of the district registry office at Howrah had left premises along with the original deed of conveyance. Only original deed of conveyance to taken back by the register. Other documents were lying in the hands of the plaintiff number 1. However, the other papers which were signed inter alia by your petitioner were kept by the plaintiff number 1 for being handed over to the intending purchaser. So this is my allegation. Allegation is that, my lord, whatever the documents required for execution of the deed of conveyance, additional documents were also signed and they taken my signature.
So it is an admitted position that
Fraud has been committed.
no, property has been sold. It is
Yes,
an
yes,
admitted
another
position.
property, another joint property has been sold out.
Okay. So this position is admitted.
Admitted, my lord. As your petitioner had nothing further to do so, as your petitioner was in a hurry, your petitioner had left the room after taking the pay order, which was prepared in the name of your petitioner towards part consideration, money which was receivable by petitioner. Paragraph 18, my lord. Your petitioner said your petitioner was all along until the time mentioned here.
What was the consideration money did you mention?
Yes, my lord, I have also
The
mentioned.
total amount of sale and the consideration amount.
My lord, whatever the amount, my lord, mentioned with regard.
Where have you mentioned that?
My lord, I have not. My lord, actually, I don't have any instruction about the amount, consideration amount. Whatever the amount, as I have received, I am receivable, my lord, I have received it. With regard to amount, my lord, I don't have any dispute, my lord. For that reason, I executed the deed of conveyance, and what documents the plaintiff number 1 asked me to sign, on good faith, I have signed, my lord. That good faith turned into a bad faith, my lord. Your petitioner said your petitioner has all along and until the time mentioned hereinafter resided at the said family dwelling house along with his family members. So till 29th August 2015, according to them, I was residing at 77F Korea Road. Thereafter, my lord,
How many suit properties are there total?
there are, my lord, so many properties were there, my lord. Rest
So
of the
one of the property was sold.
rest of the properties settled, my lord. Only one property, 77F
Rest
Korea
of the
Road.
properties it was settled. One property is
Yeah, rest, but that was the residential
Not the
house.
subject matter of the suit. Subject matter of the suit is only one property.
Only one
subject matter
property.
of the suit.
One property.
One property.
One property.
Other shares,
And
fixed
the
deposits.
sale is
The
with
subject matter of the suit.
Oh, this sale is not the subject matter of the suit.
No, my lord. Another property, Howrah property, my lord.
Not the
It was not within the schedule of the plaintiff of this suit, my lord. And first terms of settlement with regard to fixed deposits, shares, and others movable assets, my lord. Your petitioner said your petitioner has all along until the time mentioned herein have resided at the said family dwelling house along with family member. In fact, since the death of the parents of your petitioner and his immediate family members were the only residents of the family. Your petitioner had also has his chamber at the said premises. The plaintiff number 1 for a long is settled in Mumbai. That is another issue. So, my lord, the defendant, being the petitioner before your lordship, my lord, having his chamber, he was residing at that very particular house, my lord. Question of relinquishment of that property does not and did not arise. On February 2, 2016, by taking advantage of the absence of a what, my lord, after taking and procurement of my signature, what they have done, my lord, I have also explained. in the subsequent paragraphs, paragraph 19, on February 2, 2016, by taking the advantage of the absence of your petitioner and his family members from the said premises, some miscreants and unknown persons had broke upon padlock and put on the main gate of the said premises and had forcefully trespassed into the premises. Your petitioner was informed by of the same by his neighbors over phone. So when your petitioner was not in the house, they broken the padlock and they taken over the possession. Thereafter, my lord, what I have stated, my lord, I have lodged the FIR. I have lodged the police complaint. Police came in at my premises and I entered into the premises with the aid of the police, my lord. On paragraph 13, my lord, I have also submitted written complaint. When the written complaint as aforesaid was lodged by your petitioner, with the officer in charge, Korea Police Station, the officer in charge immediately instructed one of the officers to visit the said premises and to submit a report after inspecting the same. The said officer in charge had also instructed your petitioner to accompany the said officer to secure his possession over the said premises and if necessary to put his own padlock there. Accordingly, your petitioner along with the said officer, Korea Police Station, had visited the said premises at about 11:30 p.m. when it was found that the said premises and particularly the grill gate outside the premises was locked. On the basis of the instruction given by the officer in charge, Korea Police Station, your petitioner has also put his own padlock in the said grill gate in presence of the said officer, Korea Police Station. Thereafter, while your petitioner was running from pillar to post to secure his possession over the said premises, your petitioner was served with two several notices dated 11th February 2016 and 23rd February 2016 from the decree department of this honorable court. So this is the knowledge of the passing of the impugned order and decree, my lord. So when the notice came from this honorable court at the residence of your petitioner being came to know that an order has already been passed that the residential house, that is 77F Korea Road, has been relinquished by me on the basis of a terms of settlement. According to me, no terms of settlement ever signed by me after 13 March 2015. So if I signed any terms of settlement subsequently, my lord, I should have knowledge. I know that what I have signed. I did not have any knowledge about it. Even my lord, my advocate on record did not have any knowledge about it. Only from the court notice, on the notice from the decree department, I came to learn that a draft decree is decree dated 8 September 2015 in the suit will be settled by the landed register insolvency. And thereafter, my lord, I contacted with my nephew, my lord, the son of the plaintiff number 1. He is also an advocate of this honorable court, my lord, and he guided me that nothing has been happened, it will be resolved. After that, my lord, I tried to find out the actual facts, my lord. Thereafter, I came to know that already the suit is disposed of by a compromise degree, my lord. Thereafter, I filed this application for recalling of that degree, my lord. In their opposition, my lord, what they have stated, my lord, because at the time of passing of the impugned order on 8 September, my lord, I am coming. 8 September 2015, my lord, prior to that, no notice was ever served upon my advocate and record that the matter is going to appear on such and such date. No mentioning notice was given, my lord. They have also admitted in their affidavit in opposition, my lord. I have also annexed the list, my lord, kindly consider in my application, my lord. My lord.
Yes.
Yes, my lord, I am coming, my lord. My lord, consider page 35, my lord. First item, my lord. CS 309, Sudhir Ranjan Das and another versus Surojit Das. The matter appeared as to be mentioned, my lord.
Yes.
To be mentioned, my lord. And it is the list for 8 September 2015, my lord. On that very particular day, the judgment about the terms of settlement filed and the degree obtained, my lord. So at least if I sign, for the sake of argument, I admit that I have signed. At least one notice should be given to my advocate on record. At least I should be informed that the matter is going to settle on such and such date. On the date of to be mentioned, the judgment has been passed. No knowledge was within the no knowledge was of me, my lord, as well as the advocate on record. No notice was ever served upon my advocate on record that at least my advocate on record was by having the knowledge that a matter is going to appear on 8 September 2015 as to be mentioned. and on consent of the parties, the matter will be disposed of, the terms of settlement to be filed, my lord. According to me, my lord, my advocate on record, having no knowledge about it, because I did not instruct, number one. Number two, I have not put my signature on the terms of settlement. And whatever the signatures they have procured on 29th August 2015, on the basis of the transaction of a deed of conveyance of separate property.
29th August 2025.
25, my lord. Like my 15, sorry, my 15,
Yes,
my lord.
and this matter was taken up when? Before
My
the
lord,
court?
to be mentioned, my lord.
No, to be mentioned on which date? After how many days?
My lord, how 20 August, September, 29th August, September. My lord, about 8 to 9 days, my lord. 10 days. After 10 days.
This is 8th September.
After 10 days, my lord. It is a note about list of 8 September 2015, my lord. It is my residential house, my lord. I am fighting for this, my lord, since long, my lord. I do not want to relinquish my right on and over the ancestral house, my lord. They have taken the property with their own by procuring some documents, my lord. My lord, in their opposition, my lord.
Yes.
Yeah, video opposition, my lord, at page 20, paragraph 28, my lord. Page 20, my lord, from my lord 1, 2, 3, 4, 5, 6, 7, 8. My lord, after 10 lines, my lord, terms of settlement. The terms of settlement was accordingly drawn up and finalized approved by the parties. The defendant expressed his unwillingness to have the said terms of settlement signed by his advocate on record, claiming that it would cost him unnecessary and unavoidable.
Okay, before the registered insolvency, the petitioner did not appear.
No, my lord.
No, after the matter decree is passed, a date is fixed by the registrar
My lord, yes, my
for
lord.
the settlement.
My lord,
Settlement regarding drawing up.
my lord.
Before that, for that purpose, he did not appear. He obtained adjournment.
Yes, my lord. According to them, because my lord, when I came to know that the decree has already been passed, compromise decree, my lord, I have to take steps, my lord.
So, any notice was issued by
No,
the registrar?
no, my lord.
No, by the registrar.
By the department issued. From that notice, I came to learn.
Okay. Where is that notice you have annexed?
Yes, my lord. I have stated it. Not I have annexed.
No, why have you not annexed
Yes,
it?
I am coming. I am coming.
Yes. Yes, page 29.
My lord, I am coming, my lord. Yes, my lord. Page 28, 29. Page 28, first notice. Page 29, second notice. And thereafter, my lord, draft settlement. Thereafter, the list, my lord. They have initiated the suit. They are trying to grab the property, my lord. What they actually get, according to suit, they will get, my lord. On the basis of a compromise degree, why they are impressing on such compromise? When I came to learn, my lord, from that day, my lord, I am taking steps, my lord. I have been misguided by my nephew, my lord. For that reason, my lord, I could not take steps after about knowing the fact on time. In their opposition, they have taken 1 point, my lord. The delay has not been explained, my lord. With regard to delay, my lord, I am coming at page 20, paragraph 32, my lord, kindly consider. Of my application, page 20, paragraph 32. In view of the statement made herein above, and as your petitioner at all material time was more concerned with the recovery of the possession of the said premises, comma, delay, if any, in making the application may be condoned by this honorable court. So delay, I have already stated before your lordship, my lord, and prayed for condonation, my lord. They have taken this point in their opposition that no explanation is given in the application or no prayer is being made for condonation of the delay, my lord. With regard to delay, I have stated, and
So the petitioner, that is, petitioner is in the legal profession.
yes, my lord. Petitioner's father was a barrister of this honorable court, my lord. Petitioner is also an advocate, my lord. He is now aged above.
The relationship between the parties are all brothers, sisters.
Brothers and sister. One brother and sister, being the plaintiffs, have filed a suit, or myself being the another brother fighting, my lord.
Yes. Yes, that's all.
No, my lord. With regard to my lord, only 1 point, my lord. My lord, only 1 minute, my lord. My lord, come at page 35 of the affidavit of opposition, my lord, paragraph 50, my lord. I say that the notice of mentioning was not given to the defendant's advocate on record at the defendant's request, as he wanted to economize on his legal expense. As stated above, the defendant had informed that he would inform his counsel to remain present in court on the date of mentioning and hearing, inasmuch as the said counsel was not charging him any fees, as it is personal matter. So prior to mentioning of the matter, no notice was given. They have admitted, my lord.
No, question is there any relation between the
Advocate on record.
counsel and the defendant?
No, 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 my lord. No.
Advocate on record and the defendant?
No, 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 no.
No relation?
No relationship. My lord, kindly come at, my lord, page 38, paragraph 55, my lord.
Para 38.
Page 38, paragraph 55. The deponent what has stated, my lord, on affidavit. The statements made in paragraph number 1 to 52 above are true to my knowledge, and also based on information derived from my son Dipankar Sudhi Das. He having no personal knowledge, what he has affirmed, what he has stated before this honorable court on the basis of information as I derived from his son, believed by me to be correct, and those made in paragraph such and such. So the deponent having no personal knowledge about the affidavit. Only he has affirmed this affidavit on the basis of the information as his son Dipankar Sudhi Das supplied or
No, during the meeting,
my lord.
during the meeting when the conveyancing took place, he was present, so definitely will have knowledge.
No, my lord.
At the time of
my lord, what on affidavit what he has stated?
See, at the time of execution of the deed, was he present?
On affidavit what he has stated? I based on information derived from my son.
Well, very well. Some may be information, some are knowledge.
From my son.
Regarding, you see, regarding this, whether notice was served or not, it may not be directly from his knowledge, but whether he was present when the deed of conveyance was executed,
at that
then
point
that definitely has to be
within
within his knowledge.
So, my lord, according to my lord, on the basis of the fraudulent activities, the compromise settlement has been prepared. My lord, thereafter, my lord, the decree has been obtained. My humble submission before your lordship, that decree under impugned order may kindly be recalled.
Yes.
If your lordship, my lord, asks me to, my lord, file short notes of argument, I am ready to file.
Yes, you
3
submit.
points. 3 points. First, your lordship would kindly have a look at paragraph 28 of my affidavit in opposition. at page 21. This continuing paragraph 28, I shall place one sentence before your lordship from this affidavit. Has your lordship got it?
Yes.
When the matter was, first line, when the matter was listed,
28.
para 28, it continues from page 20.
Yes.
At page 21, the first line at page 21, at the top.
Yes.
When the matter was listed for final disposal on 8/9/2015, the defendant was personally present in the court with his said advocate. The signed terms of settlement was filed, and this honorable court was pleased to pass final decree in the said suit on the basis thereof. So, my lord, what statement have I made on oath?
With
That
the
on
said
that date,
advocate means said advocate on record or
with the said
counsel?
advocate, the counsel.
Counsel.
The counsel. So, what statement I have made on oath? That on 8 September 2019, the defendant was personally present in court. Kindly sees how he has dealt with paragraph 28 in the reply. Kindly takes the affidavit in reply.
Yes. Which?
Page 9, paragraph 21 deals with paragraph 28.
Yes.
There is no denial.
Para 21, page
Para
9.
21, page 9, dealing with paragraph 28. May I place it? With
Yes.
reference to the statements made in paragraph 28 of the said affidavit, I deny and dispute each and every allegation as contained therein, 7 except what are specifically matters of record, and I further stated I never approached the son of the plaintiff number 1 for mentioning of the suit. As alleged, I did not have knowledge about the mentioning of the matter in the first week of September 2015, and it is further denied by me that any notice for mentioning was served upon the advocate on record of me, and as such, the question of appearance of my advocate on record or my counsel does not and cannot arise. I further state that I did not have any knowledge about the date, that is September 8, when the matter was listed for final disposal. So when I have specifically pleaded that he was personally present in court, the law provides, specifically provides that there has to be a denial, a specific denial, because a specific case made out by me that he was present in court. He couldn't deny. He couldn't deny that. This is number 1. Number 2.
Yes.
Civil Procedure Code does not mandate the advocates to sign on the terms of settlement, on the compromise. Kindly takes a look at Order 23. Kindly takes a look at Order 23.
Yes.
Rule 1. This is withdrawal of suit or abandonment of part of claim. Then kindly sees 3, Rule 3, which is compromise of suit.
Yes.
But in our case, possibly Rule 3 would be applicable. Compromise of suit. When it is proved to the satisfaction of the court that a suit has been adjusted wholly or in part by any lawful agreement or compromise in writing and signed by the parties, or where the defendant satisfies the plaintiff in respect of the whole or any part of the subject matter of the suit, the court shall order such agreement, compromise, or satisfaction to be recorded, and shall pass a decree in accordance therewith, so far as relates to the parties to the suit, whether or not the subject matter of the agreement, compromise, or satisfaction is same or subject matter of the suit. In the parliamentary. So, my lord, your lordship would see Order 23, Rule 3 prescribes, my lord, an agreement of compromise to be in writing and signed by the parties.
Yes.
The factum of the agreement being signed by the defendant is not in dispute. The defendant is trying to circumvent that by 2 means. First, I did not understand that. That was signed along with Howrah property documents. 2, my advocate did not sign.
Oh,
Second point.
This petitioner is in the legal profession.
Yes.
What is his age?
Presently 73.
73.
73. At that point of time, at least 63.
Yes.
Okay, now another question is this. Let me see the terms of settlement.
Yes. Kindly takes a look at my affidavit in
So
opposition.
in accordance with the terms of settlement, the defendant is to forego his right to the residential property.
Yes.
Let me see the terms of
Yes.
settlement.
My
That
lord,
is
will
page 68.
page 68 kindly sees of my
Let
affidavit in
me
opposition.
see the terms of settlement. And the subject matter of the suit is only this property.
And also other
property.
movables were there. Those were
No
set.
immovable property.
No.
Regarding immovable property.
Immovable property only one. Only one. Only one.
The other property is not the subject matter of the suit property.
That has already been settled, my lord, in terms of the earlier terms of settlement.
That has already been settled.
That is anyway.
Not the subject matter of the suit.
Pre-litigation settlement.
Not the subject matter of the suit.
Yes.
Subject matter.
Subject of the suit, but
Previous terms.
previous terms.
Well, previous terms, I'm sorry. Subject, not the subject matter of these terms. Subject matter of the suit settled by the previous terms. I shall show that also. There were 2 decrees. One part decree where previous terms were acted upon, settled. Those pertain to certain immovable properties and movables, except this immovable property.
So this was not within the purview of the terms of settlement.
Of the first terms of settlement.
That in this particular suit.
Yeah, no, suit is one.
Yes, that is what I am asking.
In this suit, there are other properties also. In these terms, it is only one immovable property.
One immovable.
In the previous terms, when a previous decree was passed in the suit, in this suit, those pertain to other properties.
No, in those decree, in those settlement, the petitioner, that is the defendant, got any property.
Yes, yes. I shall show that. I shall show that.
Anyway, so
Kindly
let
sees
me
these
see the
terms.
term.
Yes. Would you, is it your lordship's pleasure that I take your lordship to the first terms?
No, let me see this
Very
terms
good.
first.
Kindly sees page 69. This is only pertaining to 77F Korea Road. My lord, why this was given to me, your lordship would find from paragraph 4. The plaintiffs, which is my clients, had waived their rights or claims over their 2/3 share in the sale proceeds of the shares which were sold by the defendant. The present value of the said shares would be in excess of rupees 5 crores. Kindly seize the dishonesty here. They sell the shares. I do not get the value of that shares. I forego that. In lieu of this property, now they want this property to be back. So they want the cake and they want to eat it.
There is
too.
only one defendant.
Yes. So kindly seize, they have already sold the shares worth 5 crores. I have let go of my rights. I was entitled to 2/3, which is around 3.5 crores.
See, this entire terms of settlement is under challenge. Okay.
Correct.
So this cannot be treated at this stage. Cannot be treated to be sacrosanct. If you deal with this, then other terms should also be gone into.
No, my lord. I am only attacking this ground of this, the challenge of this, by saying that this 2/3 sale proceeds, which I was entitled to from the sale of shares, I have already let go of that.
Just a minute.
That has already gone in 2015.
Then, okay, this is plaintiff has waived their shares. Yes. Now come to 5. That is
Yes,
present.
5. The present value of the said shares would be in excess of 5 crores.
Okay.
I have already let go of that.
Yes.
Now, in lieu of the concession granted by the plaintiffs, in lieu of, the defendant, including his heirs, gives up his right with respect to the residential property. So, my lord, it's not that something was taken by me, excluding them, excluding him. They sold the shares, got 5 crores. In lieu of that, I have got this property. And he relinquished his right in that.
Just a minute. In lieu of the concession.
Now kindly seize the situation. They had the shares, they sold the shares, I was entitled to 2/3, I had foregone that. I had foregone that pre-2015. So today I cannot claim that. Now today they are saying that recalls this decree so the property comes back to me.
How many pages were signed by the parties?
All pages.
One.
All pages. Starts from 68. Every page is signed. Every page. And the signature is not disputed.
So 3 pages were signed.
4 pages.
4 pages.
68, 69, 70, 71.
Any contention that this petitioner was suffering from some eyesight problem and all these things?
These are, my lord.
No, whether there is any contentions?
No, no. Nothing of that.
Yes, then.
Now,
Actually, let me see the other terms. Have you annexed those?
yes.
Yes.
Kindly see page 47.
Yes.
Now, because of the fact that
This is the another terms of settlement.
another terms of settlement primarily deals with movables.
Yes.
But here at page 58, my lord will find also signed by the advocates.
So this is with regard to
Everything, all other suit properties barring Korea.
let us see what are the terms.
Yes.
Regarding that 5 crore, where do we get that?
No, this is not there. This is not there. That is part of the next term.
Okay. 15 lakhs from this bank accounts.
আছে বাট ওইটা এটা নয়, তুমি যে ছেড়ে দেবে ওটা নয়, সেটা বলা নেই এখানে, সেটা ওইখানেই বলা আছে। No, this mentions of the shares, but
The valuation is not there.
valuation is not that. This is valued at 5 crores, which is there in the second.
Okay, now the question is it still contended in the petition that the contentions are all false? The terms of settlement are all false? Any contention in the petition that maybe he was misled or something? That is one thing. And after he came through these terms of settlement, this is absolutely false. Anywhere it is stated. One of your contention is that he did not specifically deny, that is paragraph 28. That is one.
His presence. That is my first point.
Other is, did he specifically deny the contents of the terms of settlement as false? If he has said, he must have said in the petition.
My lord, page 19, paragraph subpara 1 kindly
Page
consider.
19.
Of my application, my lord.
Page para 19.
Yes, my lord. Page 19,
Page
subpara
19.
1, my lord. The plaintiff suggested as a fact that your petitioner has knowingly signed
Okay,
a terms
just
of
a minute,
settlement.
just a minute. Yes.
The plaintiff suggested as a fact that your petitioner knowingly signed a terms of settlement which is not true and which the plaintiff did not believe to be true. And my lord, Kindly consider the first terms of settlement, my lord. Paragraph 55 of the affidavit of opposition, where, my lord, the intention of the parties have clearly been explained, my lord. Page 55 of the affidavit of
55.
opposition, my lord.
Okay.
Everything will be clear
Okay,
from this
now just
paragraph,
a
my lord.
minute. So
It-
regarding shares, what have you stated? Shares, plaintiffs waive their rights over the shares.
Yes. So 5 crore shares, plaintiffs were entitled to 2/3, which is around 1.5 crore,
According to you,
3.5 crore.
according to you, the plaintiff has sold the shares.
Defendant has shown.
Defendant has sold the shares. Okay.
And in lieu of my concession to get 2/3, the defendant has waived his right in the property.
Because these will not find any place in the petitions or affidavits. It is only part of your terms of
Terms of
settlement.
settlement. Now, in the pleading with
That
regard
he
to
has
fraud,
sold, had it been a part of your pleadings,
that was already sold.
yes, in the terms of settlement, it is there. But you see, although he has not stated that it it is false, but in your affidavit in opposition, have you stated that he has already sold for all these things?
I'll just check. I'll just check. Till such time we check and get back to you, your lordship, on this. Two other facts. Now he has, in breach of these terms, sold this property to my learned friend, my lord, appearing for the intervener.
Which property?
This property. So, A, this property was a joint property, subject matter of the partition suit. B, that was to come to me and he was to relinquish that.
So sold means what? So sale of any shares
No,
or entire
entirely sold.
to you by whom?
Yes, by the
Who are-
defendant. By the defendant. Kindly seize the
Huh?
conduct of the defendant.
By the defendant.
Yes,
In 2024.
Saying that he is the
saying that he is the sole owner. Kindly seize the conduct of the defendant. Very important.
Yes, your intervention application is very much necessary now, I think.
Because of the pendency of this
It's this intervention
Because now-
application is very much necessary.
My lord, may I say this? Suit has been decreed. Suit has been decreed. So,
Now, after the,
equally-
no, 2024, according to you, it's your oral submission because there is nothing on the record, save and except your learned friend has made an application.
no, in that application, affidavits are exchanged.
Yes, in that application.
In the intervention application.
the affidavits are
And my substantive
So
application
you have
is also there.
purchased the property for valuable consideration.
paid it, you have bought it only on the basis of an affidavit approved by the defendant within the process magistrate stating that he's the only heir of the deceased.
Let the defendant put that money in the table.
No, very well.
Let the defendant put that money.
Now I see this application is also necessary to
But-
decide this issue.
Lord, I would say this application would not be necessary at this stage, because if your lordship is not
Because you have-
minded,
Because you have stated that.
no, my lord, may I indicate? Your lordship will kindly give me 1 minute. If your lordship is not minded to recall the decree, then in a disposed of suit, there cannot be any question of intervention.
Whether I recall or whether I don't recall, I have to pass a reasoned decision. Okay.
Absolutely, I bow down to
So,
that. My
so to arrive at a decision, this intervening
Well,
application is necessary.
to this in
Let me
this
see the contents of the
May I,
application.
may I just make one humble
Yes.
submission, subject to my lord's kind consideration? When this recalling application was filed in 2016, no third party right was created at that point of time. So, on the anvil of the facts prevailing as on 2016, the recalling application was filed. Your lordship would kindly, in my humble submission, my lord, subject to my lord's kind consideration, would limit this application scope to that stage. Subsequent creation of third party interest cannot possibly be a guiding factor for recalling or not recalling a decree. If the decree is obtained by fraud, then your lordship may recall.
Yes,
If your
now
lordship,
actually,
But now-
that application is necessary, according to you, to consider the conduct of the party.
that is later, yes,
Subsequent conduct.
subsequent, but that is in my humble submission for the adjudication of a decree, for one adjudication of an application for recalling of a decree. A subsequent third party interest created after 8 years possibly would
Are you
not.
in possession of the property?
No,
We were in possession of the property. We were there in the possession, we were forcefully dispossessed by misrepresentation of an order passed by the.
In 2024, you purchased the property.
there was a GA application, general application filed by the plaintiffs here.
My
In
clients.
GA7 lordship, where they had stated that they needed some interim order protections from. Allows me a moment, lordship.
But we come to learn that third party interest is created, we come up with an application. In that application, there was an ad interim order passed restraining further creation of any third party interest or parting with possession. So that is there at this stage. Now the recalling application is being heard. The interim order in that application of mine is subsisting.
Maintaining the status quo, lordship. Maintaining the status quo in respect of possession of the property. Now, lordship, we did not have an idea about the GA7 application filed by the plaintiff, lordship. It was the personnel from the Karaya police station who suddenly came and said, "No, you need to go on to the property." That is my specific contention in my intervention application, which is lying pending, lordship. The affidavits are exchanged, and we were told to leave the property. Later, when we got the order of the court, lordship, we found that it was only status quo in respect of maintaining the possession, lordship. We were forcefully, we made the submissions and it is under consideration before the coordinate bench, lordship.
Anyway, let him complete.
Yes. Now, my lord, two things. My lord, they get benefit of the terms insofar as the shares are concerned. They get that shares. They violate these terms by selling the property when the application for recalling of the decree is pending. Now, very interestingly, when this application was moved at the interim stage, there was an order of protection passed. This sale is also in violation of that. May I place that? That is in GA7. But this is the first order passed in. No. Are আমাদের recalling এর first order. Recalling এর application first order should be G7. Kindly gives me a moment, Philip. File first order আছে AG এর I'm grateful to my learned friend, my lord. May I just hand up, my lord? I shall bring a copy on the next one. Kindly seize page 125. Sure. Now, this is the first order.
Question is regarding the sale. Have you taken this in your affidavit in opposition?
Yes. In GA7, I have taken GA6. Kindly seize page 125. When this application, which your lordship is hearing, this application has been taken out on behalf of the defendant for recalling of an order dated 8 September 2015 passed by this court, whereby suit was decreed in terms of such and such. As prayed for, let affidavit in opposition will be filed. Then kindly turns to the next page. Kindly seize the penultimate paragraph. In view of the submissions made by Mr. Such and such, in the meantime, the property in question shall not be dealt with. No formal order is passed. It is further made clear that the plaintiffs shall also not deal with the property in any manner. So submission is made by the learned senior counsel that this property will not be dealt with. Now they will come up and contend, I did not instruct my learned senior counsel to make the submission. Kindly visualizes the stand taken on oath. They say that they have not instructed the advocate. So this is pointing fingers at the learned advocate also, who is appearing without any authority. It is not only restricted to parties inter se. This is in this application, the interim order in this application. So they will now say that I did not instruct the learned senior advocate to make such submissions. So all order goes, everything goes, terms of settlement goes. So, my lord, if your lordship, my lord, believes this stand
Where is this?
of a litigant.
Question is Where is the enclosure that is annexed, that of the sale deed? Have you annexed that? Subsequently, affidavit in opposition is filed when?
That is 2016
that-
we had filed.
No, in 2016 we had filed.
Filed.
The opposition.
This was
So-
created in 2024.
Sale deed we have annexed in
2024. So he did not file in a supplementary affidavit to bring into record that sale.
No.
GS7.
Because that really, the subsequent conduct can possibly not really have a bearing on the recalling of the decree, my lord, in my humble understanding, subject to your lordship's kind consideration. But I was pointing out the conduct that they have taken away the shares, they have not given that. This property was to come to me, and if the decree is recalled, at least it would be reverted into a joint, it would revert back to a joint property.
Yes.
So any which ways the defendant does not and cannot have an absolute right. This terms of settlement gave me the absolute right. Even if this is recalled, he will not have an absolute right, but he has pocketed the entire money. He has pocketed the entire money from the sale of shares. Now, the issue of the advocate being not instructed. What I was submitting, my lord, this is not really restricted to the parties inter se. This is alleging an offense under the Advocates Act also against the concerned advocate, that he has appeared without instructions. So this is of a serious nature. This is not only restricted to, my lord, the parties. So if these kind of submissions are believed by the court, my lord, then tomorrow, my lord, because every day we do not get instructions every day in message or in, my lord, email that you appear and make these submissions. We have been briefed, we have been given back sheets
See,
to appear.
only in case
we
of
appear.
consent order, okay, consent order or compromise or whatever it is,
The party has signed.
instructions are required.
The party has signed.
Contest the matter, you see, instruction is not
Yes,
required.
but the party has signed.
Yes.
He has not disputed his signature. He was present in court. He has not denied that. So, my lord, if he, in his commercial wisdom, thought fit that he would not inform his advocate on record, that is his choice. But for that, but your lordship would never, my lord, inquire from all of us, where is the advocate on record? Is he appearing today? Your lordship takes us on our face value, believing that the person appearing has the authority to appear. Otherwise, your lordship would have to do the ministerial work in every matter. Where is your advocate on record? Did he ask you to appear today? Did he ask you to make these submissions today? Your lordship believes us. That is the relationship between the bar and the bench.
And he is also an advocate practicing.
Yes, that's all.
Himself.
Yes. And my lord, I have shown from the orders and the minutes of the commissioner, he has all along appeared. So the submission, I'm sorry, the pleading in the paragraph that, my lord, he had never instructed the advocate, the concerned counsel to appear. Never. That is a false statement on oath. Once this is disposed of, I shall take out an application under section 340. This is a perjurious statement.
You just, on the next day, both of you come with some written notes and compilations of all the orders.
But only humble request, my lord, if this could be taken up any day this month, my lord.
Yes.
Any day, my lord, subject to my lord.
Along with GS7 filed by this, in which is before the court of bench. My only request would be that the matter be taken before that.
No, I request.
Anyway, I have concluded the hearing. Okay,
Yes.
learned advocates for the parties and learned advocate for the intervening applicant who has contended to have purchased the suit property are present. Heard the learned advocates. As hearing is concluded, learned advocates are granted opportunity to file written notes of arguments on or before. Okay. Learned advocates are granted liberty to file written notes of arguments on 26/8/2025. I'm keeping it on 26/8 as to be mentioned. Let this matter appear on 26/8/2025 under the heading to be mentioned. So file your written notes.
I'm so grateful.
Yes, all of you.
Yes. But possibly my learned friend appearing for the intervener does not have any.
I have
objection.
recorded her presence and
But in this application, she is not even added as a party.
oh, but you
It's a
see,
recalling application.
court requests to see the subsequent events also.
Correct. I leave it to you. I'm so grateful.
May please, Your Lordship. Well, this is my application for revocation of grant of probate. Well, there are two applications in the serial numbers, one after the other. Oh, I'm led by Mr. Ghosh. I'm sorry.
My lord, before I take my lord through the applications, if I may just show my lord one provision of revocation, section 263 of the Succession Act. If my lord just takes that up once more. He didn't get through. He died. His daughter. I'm sure.
Yes, 263.
263.
Yes.
My lord, revocation or annulment for just cause.
Yes.
The grant of probate or letters of administration may be revoked or annulled for just cause. So it's a very broad scope, my lord. Then the explanation is given. Just cause shall be deemed to exist where A, the proceedings to obtain probate obtain the grant were defective in substance. And I will be relying on this clause, one of the clauses. Then the grant was obtained fraudulently by making false suggestion or concealing from the court something material to the case. I shall also be relying on that. The grant was obtained by means of an untrue allegation of a fact essential in point of law to justify the grant, though such allegation was made in ignorance or inadvertently. This will also come under A and B. There'll be a then the grant has become useless or inoperative through circumstances. I'm not on that. E, my lord, is a important part of my argument. So just cause will be deemed to be exist where the person to whom the grant was made has willfully and without reasonable cause omitted to exhibit an inventory or account in accordance with the provisions of chapter 7 of this part, or has exhibited under the chapter an inventory or account which is untrue in a material respect. So, my lord, your lordship knows that after probate is granted, after probate is granted, the executor is to file an inventory and file his accounts.
Yes.
Now that is under 317. My lord will just see. Section 317. An executor or an administrator shall, within 6 months from the grant of probate or letters of administration, or within such further time as the court which granted the probate or letters may appoint, exhibit in the court an inventory containing the full and true estimate of all the property in possession and all the credits and also all the debts owing by any person to which the executor or administrator is entitled in that character, and shall in a like manner within 1 year from the grant or within such time as the court may appoint, exhibit an account of the estate showing the assets which have come to his hands and the manner in which they have been applied or disposed of. The High Court may, etc. Then the procedural thing. So now if my lord comes back to 263E, 263E, this thing they have not done, the executor. This is an admitted fact, I'll show my lord. The person to whom the grant was made has willfully or without reasonable cause omitted to exhibit an inventory. So till the time
Yes.
So till the time this inventory and accounts are made, the application is deemed to be pending. The point that I'm trying to make. Now, what happened is when we moved this application for revocation, we raised this point. Said that there's from the records, it appears no inventory, no accounts have been filed. Then a report was called
When was
for
the probate granted?
many years ago, Malad, 2002, no? 2000, well, 2000, in the year 2000. In the year 2000, it was granted. This application we have taken out in 2023. So basically, one of the obvious grounds that they have taken in opposition, I'll take my law through the facts. I just wanted to make this point clear why there are two applications. So I made an application for revocation. When we moved it, I took this point because we did not know at that time they have not filed an inventory or etc. We did not know about the probate according to us. Then the report was called for by Justice Mojumdar, and from the report it appeared they have not filed. So in my reply, I have taken this point elaborately. This is also a just cause for revoking the probate. Now, to correct that, if it was a mistake or a lacuna or fault or whatever that is, then my learned friends have taken out GA2 asking for condonation of delay and for filing of inventory and assets. So, admittedly, that means this, I don't have to prove anything else. But their application itself shows that at the time when I made the revocation application, there was no inventory of assets, nor was there accounts filed as required under section 317, read with 263E. So this is the main point. So now they have made that application. And this helps me in another way. I'm going to take my lord through the facts. The other way it helps me is if my lord sees on a plain reading of the Bare Act 263E, this 263E, if I am to rely on that ground,
Yes.
I can only make the application. I can make the application right up to the point when he has exhibited an inventory or accounts. So if he has not done it, as on the date when I made my revocation of application cannot be barred by time. Because the first point that in the affidavit in opposition they have taken is that this application is barred by law of limitation. Because the probate was got long back in 2000 and this application has been made 20.
Period of limitation is 3 years.
3 years from when the right to apply for revocation accrued. This right to apply, that's how the courts have tempered it down. If I may put it this way, the history says there was
3 years from the date of the
historic
accrual of right.
accrual of right. But historically, there was no date for limitation for probate. Probate is actually the stamp of the court that yes, this is the authentic document. That is it's an administrative job. Unless it is disputed, then it becomes a testamentary suit. So for years, there are old judgments also. There is no question of probate, limitation. Because a person who gets a will doesn't have to go and get it probated in order for that will to be effective. A normal will can be. It's only if you have to rely upon it in a court of law, then only you must get probate. Only when you want to rely on the court of law. That's section 213. And in other states, which were not a part of the act of the presidency towns, etc., they don't even have probate. In Delhi, UP, etc., you don't require to take a probate separately. Your will, the document you make your claim accordingly. Even in money suits, probate will is being probated in that sense. Well, you prove the will in the manner of the.
There is no separate proceedings.
There is no probate proceedings. So probate proceedings are so therefore historically there was no time. But then the Supreme Court passed a judgment in about 2008, and it was Justice Pasayat Manoj in 2008 and 2009. There are two decisions. He said no. If a application is being made to court, there has to be a period of limitation. If it is not specified in the Act, then it will be 3 years as per the residuary article.
Yes.
So the residuary article says that 3 years will begin when the right to apply accrues, when your right to make that application accrues. So it is not that immediately 3 years after probate has been granted by this court, it becomes barred. It is only when I get the knowledge, then only I can apply for revocation. So now there is limitation.
Anyway, after all,
but-
it is an application, it can be condoned also.
Yes, it can be condoned. And secondly, the courts have also interpreted it must be shown that your date of knowledge is important. Like when your right accrued, if I didn't know something, then it didn't accrue. But be that as it, just to counter this argument, my lord, there's a lot of jurisprudence on both sides, whether how limitation, that's also a question of fact. But if my lord is with me as far as 263E is concerned, it says that I can apply for revocation if the inventory has not been exhibited. Now, admittedly, the inventory has not been exhibited even till date.
Yes.
Therefore, my lord, the question of limitation also will not arise. So this is my submission, my lord. That's
With GA1.
in GA1. This is my submission regarding the maintainability. I'll come. There's on merits. I have lots to say. So logically, it cannot be that the probate is granted in 2000, therefore it's barred by limitation. But even now, they have come before my lord after me in GA2 saying that I want to file the inventory. So I'm in this one aspect, and it's a question of an admitted fact of
GA2 is their application.
Yes. Non-filing, for the non-filing of the inventory, I'm saying a right has accrued to me to apply for revocation in 2023. Quite apart from all the other facts that I'll appraise my lord of presently.
Yes. What is your relationship with the testator?
So the deceased, I am the daughter of the deceased. He had two daughters. And my learned friend's client, the executor, the alleged executor of the will, we used to always call him a brother, but he is not an adopted son, he's not a natural son. But we've always treated him as the brother.
A will was contentious or non-contentious?
No, I'm coming to that. So the two sisters, and if I may use the expression stepson very broadly, because one of the points we have been forced to take is he is not an adopted son. And he is not the natural son, that is admitted. But so therefore, of course, I've treated him as a brother all my life. I have to say that. But now we are on a legal point. What is your right to the property? So what happened is the father had appointed Sajan Pasari, my lord, as the executor. He got probate in 1999. The
2000.
Gentleman died.
Oh, 99.
And
2000
he got the grant of probate. And his contention is, I'm his elder sister, I signed the affidavit of consent. So both sisters, he got them to sign 2 affidavits, and we gave our consent. And the mother, and the deceased's wife. So now, as far as I am concerned, my client is concerned, she resides in Delhi. She's been married, etc. She had signed in good faith whatever documents her brother had given her. She had signed it. Then, when the mother died, she had come back to Calcutta, which was more recent, I think in 2022 or 23, or sometime then, my lord. I'll just tell my lord the date. When the mother died, when she came back, that is when, out of curiosity, they all well-to-do persons, they were not really bothered about what was happening with the property.
But they had knowledge of the will.
No. So
they did not have knowledge of the will.
When the mother died,
yes,
my lord, the brother, I'm calling him the brother, again, my case is that he's not. So the brother started avoiding answering my questions. This is our case. So I filed a partition suit in Delhi for the partition of the properties of both my parents. I filed that. In that partition suit, an application was taken out under Order 7, Rule 11, where they said this suit is not maintainable because father has given a probate. I am the executor. I have got grant, and my client, the sister, has given consent. So that is my date of knowledge when I found out that he is talking about a grant of probate of which I had no knowledge. I don't know if I had knowledge or not, that
Oh, so question is, your ground for annulment, that is for revocation, is both on the ground of
AB,
not taking E.
E is the final ground, which came up after
So
I
A
filed
is
that.
there,
A is there because B is there
B is there,
fraudulently. Yes,
as well as E is there.
and C also in a way, because I'm saying that
No,
that
no, in the
consent affidavit is not it was not meant to be a consent affidavit. So A, B, C, I'm coming in. Now, when I filed it, on that basis, I filed the revocation. When I filed it, I frankly told my lord that we found out then that the inventory hadn't been filed. So E is an additional ground that I've taken in my affidavit in reply.
So the question now, you see,
If my
yes.
lord only decides on E, I win anyway. I don't have to go into the
any
merit.
provision was made for your client in the will itself, any property, any provision. Anyway, all these things will be taken into consideration.
I'll say that one.
So you
It's,
cannot conclude it today. I have fixed another matter also. It's
sorry.
better you
No,
continue.
but I'm glad, Mahat, that I got this opportunity, because this is just how we are going to move the application. Because if I went straight into the facts, your lordship wouldn't find E at all. Because when we drafted the petition, that was not to our knowledge. That's why it came up. So it's
Anyway, that is to
in
be
the
taken
reply.
into consideration.
Yes, and then they tried to remedy their mistake. So I don't have to prove anything else as such. As far as the merits are concerned, my lord says anytime we'll come back. We are ready.
Yes, yes, yes.
Only next week, except for next
Yes,
week.
record an order. Because it will take some time, okay?
Yes, half an hour, 45
Learned
minutes.
advocates for the parties are present. Mr. Ghosh submits on GA1 of 2023, but could not conclude the submissions. Let this matter appear on. আচ্ছা 4 তারিখে দেখুন কিছু ইয়ে আছে কিনা 4 তারিখে Okay, 4/9/2025 at 3 p.m. Acha, item number. Yes, item number 32 also.
That is the GA2.
That is our application.
Let this matter appear on 4/9/2025 at 3 p.m.
My lord, could it be on the 3rd of September by any chance, my lord?
3rd of September. আচ্ছা 3 তারিখে আছে 3টের সময় কিছু
আমার 3 তারিখ হবে
হ্যাঁ 3টের সময় কিছু নেই তো আচ্ছা তাহলে 4 জায়গায় ওটা 3 তারিখ করে দিন 3 হ্যাঁ দুটো ম্যাটারই 3/9/2025 at 3 p.m.
Grateful, my lord.
আচ্ছা উইটনেস এভিডেন্স ম্যাটারটা
Yes, sir. Serial number 53, the goods of Dr. Posud Kumar Banerjee.
Last ही बोली May I commence?
Yes.
না 64 হয়েছিল লাস্ট, 63 হয়েছিল, হ্যাঁ 5th অগস্ট। না ওখানে ভুল আছে, আগের দিন 44 অব্দি হয়েছিল, আবার পরের দিন 44 থেকে শুরু করেছে, নাম্বারিংটা পুরো পাল্টাবে। আপনি 65 থেকে হবে চিফ, কারণ আগের দিন আপনারা নাম্বারটা 44 অব্দি হয়েছিল, আবার 44 থেকে শুরু হয়েছে, ওটা কারেকশন আমি পরে করিয়ে নিচ্ছি। এ থেকে শুরু হবে, 65 থেকে শুরু হবে, চিফ হচ্ছে, হ্যাঁ, ফার্দার এক্সামিনেশন ইন চিফ। শোন question 62, question 63 হবে। Kindly look at question 62 as it is printed, the number will change later on, so আবার নাম্বারিং এ বল, আপনি লিখবেন question 63, কিন্তু উনি দেখবেন 62 কারণ নাম্বারটা চেঞ্জ হবে। shown question 63 and your answer there too.
Reach the
No,
cemetery.
question 62, look at question 62.
When my husband and myself reach the cemetery, cremation ground. Who performed the last rites of the testator?
That question and the answer, just have a look at it, then I'll ask the question. Ligun shown question 63 and your answer there too, where you have stated, open inverted comma, a huge chaos followed as the daughters of the testator and their husbands were reluctant to allow.
1 second.
A huge chaos followed as the daughters of the testator and their husbands were reluctant to allow my husband, Dr. Probir Kumar Banerjee, to perform the Mukhagni and the last rites. Close inverted comma, full stop. How did they propose to carry out the last rites of the testator? How did they na kore, how did the daughters of the testator propose to carry out the last rites of the testator?
My sister-in-law, Srimati Archana Mukherjee, insisted that her son, Mr. Shoumik Mukherjee, should perform the Mukhagni and the last rites. Mukhagni and the last rites. This was supported by Mrs. Chandana Chatterjee, who was also present there. I later learned that Mr. Shoumik Mukherjee was the attesting witness to the testator's alleged will, and that his father, Mr. Bijon Mukherjee, was one of the executors of the testator's alleged will and the plaintiff number 3 in this particular suit. My husband and I, along with one of his cousins, went across to the Rupchand Mukherjee Lane flat to meet the testator's wife and discuss the Shraddh arrangements. As usual, Mrs. Archana Mukherjee and Mrs. Chandana Chatterjee did not allow us to meet with the testator's wife, and they categorically said that they would make all the necessary arrangements of the Shraddh ceremony. And in case my husband wished, he could attend the same, although he would not be allowed to participate or perform the Shraddh himself.
Allowed to participate?
Oh.
In your previous answer, you have referred to a cousin of your husband. Can you name the cousin?
Mrs. Indrani Mukherjee is the cousin of my husband.
What was the reason given for prohibiting your husband from meeting his own mother?
There were no reasons given, and it was the usual practice that my sisters-in-law followed after they had removed the testator and his wife to their Rupchand Mukherjee Lane flat. My sisters-in-law and their families would guard the testator and his wife at all times and kept complete control over them. So much so that the testator's mobile would be in their custody, and they never allowed my husband to either contact or visit the testator and his wife. My husband was not even informed of the testator and his wife's medical condition or hospitalization. The testator and his wife, being 90 years and 80 years of age respectively, were in no condition to go against the wishes of their daughters.
To go against?
The wishes of their daughters.
How did your husband react to the lack of access to his parents?
Sorry?
What is the question? To the lack of access to his parents.
My husband was deeply hurt.
My husband was?
Deeply hurt and extremely upset that despite his best efforts, he could not see the testator, his father, during his last days. Further, the last two hospitalizations, further, he was not even informed of the last two hospitalizations that took place prior to the death of the testator. In fact, the news of the testator's death was conveyed to him not by his sisters, but by his cousin and other relatives.
In whose custody are the medical records of the testator kept?
Considering the fact that Mrs. Archana Mukherjee and Mr. Bijon Mukherjee resided in Calcutta, I presume that the medical records will be held by them. And in any event, if they were not with them, it would be with any of his daughters, the testator's daughters.
How would you describe the relationship of your husband with his sisters?
My husband was the affectionate and caring elder brother to all his sisters. He indulged in his sisters whenever they insisted that he pays for their shopping, lunches and dinners, or the travel bills. Mrs. Archana Mukherjee who visited us daily at our Roland Road residence, took complete charge of the household matters. My sisters-in-law were aware of my husband, Dr. Probir Kumar Banerjee's illness, which he suffered from rheumatoid arthritis. Rheumatoid arthritis. Sometime in August 2008, when my husband was ill, I remember him telling the testator that should his health not improve and he had to retire from his medical profession, he would then like to go back and settle in Patna in his grandfather's house, to which the testator agreed. After a few days, Mrs. Archana Mukherjee informed my husband that the sisters felt that there was no necessity for him to settle in Patna, and that it was better for him to stay back in Kolkata, as his presence was required there.
হ্যাঁ ভাবছি পরের কোয়েশ্চেনটা কিভাবে ফ্রেম করবো, আবার তো এক্ষুনি জজ বলবে লিডিং। তুমি কটা বলেছো, জজ তার থেকে বেশি বলেছে। The plaintiff's witnesses have deposed that the testator was introduced to the learned advocate who is alleged to have drafted the will.
The learned advocate?
Who is alleged to have drafted the will by one Rajat Bubna. Bubna, Bubna, who was the testator's chartered accountant / income tax advisor. Can you please describe the nature of the work done by Rajat Bubna for the testator?
As far as I know, there was no chartered accountant by the name of Mr. Rajat Bubna who was engaged by the testator. I have not even heard Mr. Rajat Bubna's name either from the testator or from any of the family members, and I have not come across any document prepared by this chartered accountant, Mr. Rajat Bubna.
Are you aware who handled the banking or income tax affairs of the testator prior to his death?
Can you repeat the question?
Are you aware of who handled the banking and or income tax affairs of the testator prior to his death?
I do not remember who would have handled the testator's affairs post them being shifted out to Rupchand Mukherjee Lane, as they were totally under the control of my sisters-in-law, particularly Mrs. Orchana Mukherjee, Mrs. Chandana Chatterjee, and Mr. Bijon Mukherjee.
Are you aware of who handled the banking affairs of the deceased prior to the deceased being moved from the Roland Road residence to the Rupchand Mukherjee Lane residence?
Prior to the testator and his wife being moved out from our Roland Road residence, I handled the testator's administrative affairs, testator's administrative affairs, banking and financial tasks as the testator being advanced in age and also being a chronic cardiac patient who's also suffered from chronic kidney disease, was in no condition to do these tasks himself.
Can you specify the period for which you performed the tasks referred to in answer to the previous question?
This would have been between May 2008 and September 2008.
When did the testator sell his land at Sheikhpura in Patna? Sheikhpura in Patna. S-H-E-I-K-H, no?
SHEIKHPY. The land sale, the Sheikhpura land sale, would have taken place prior to my moving in to my matrimonial home in July 2008.
Are you aware? No. Kidding. Who handled the encashment and investment of the proceeds of the Sheikhpura land sale on behalf of the petitioner, on behalf of the testator?
Can you repeat the question, please?
Who handled the encashment and investment of the consideration received by the testator from the sale of the Sheikhpura land?
The testator requested me to open their bank accounts in my branch of Standard Chartered Bank, Salt Lake CF, and therefore I opened their accounts and got the pay orders encashed and deposited in the same.
Encashed and
Deposited in the same.
You have deposed today that the relationship between your husband and his sisters was affectionate. What, according to you, prompted
what according to you?
prompted a change such that the sisters prevented your husband from meeting his parents?
Yes, could you follow or will you repeat
Yes,
once
because
more?
that's a
Yes,
long
repeat,
question.
repeat.
This is one reason.
You have deposed today that the relationship between your husband and his sisters was affectionate. What, according to you, prompted a change such that the sisters prevented your husband from meeting his parents?
Post my marriage, my sisters-in-law wished me to take care of the testator, his wife, and my husband, Dr. Probir Kumar Banerjee. Although they resented
Although
the closeness that I shared with the testator and his wife, and also the position that I held in the household. They asserted a lot of control in the running of the household, also over me personally. So much so that my sisters-in-law decided when I could take my meals, make phone calls, whether or not to make phone calls from the phones that were placed in my bedroom,
from the phones
that were kept in my bedroom, and in particular, Mrs. Archana Mukherjee prevented me from using my husband's spare car especially when my own car had gone for servicing. Not only this, sometime in 2008, when the testator was admitted in Peerless Hospital in EM bypass,
In Peerless Hospital?
in EM bypass, Eastern Metropolitan bypass, Mrs. Archana Mukherjee was adamant that I travel from my office in Salt Lake every day to visit the testator and feed him lunch and go back. Apart from these incidents, the main factor which prompted my sisters-in-law's attitude to change towards my husband was the assertion which was made by Ms. Preeta Banerjee so that her father could receive his due share from the Sheikhpura land sale.
শোন পিটে ওই এর সঙ্গে আছে প্রবিট পিটিশনটা দিন বার করে দিন এটা খুলে দিন It has been alleged by the plaintiffs that the document which has been marked as Exhibit A in this proceeding is allegedly the last will and testament of the deceased testator. What do you have to say?
The testator could not have issued any will sorry, what did I say?
Issued anyway.
Executed any will, as he was in no condition to understand what was being executed or he was being made to sign.
It has been alleged by the plaintiffs that the testator was in perfect physical and mental capacity to execute the document alleged to be the last will and testament of the testator. What do you say?
I deny the testator was not in perfect physical or mental health to be able to execute any testamentary document whatsoever. As I mentioned earlier, while the testator was living with us in our Roland Road residence, he was ailing with cardiac issues, had permanent pacemaker set, was a chronic kidney patient, and suffered from occasional arrhythmia, rendering him short of breath and dizziness. Short of breath and dizziness often.
The plaintiffs have claimed that they are entitled to grant of probate of the document. That they are entitled to grant of probate of the document sought to be propounded by them as the last will and testament of the deceased. What do you have to say?
The testator could not have executed any will, and therefore the question of probate does not arise.
Examination
all?
in chief concluded.
That's it is
Examination in chief is of this witness is concluded.
okay. Okay. Do you want to start any?
One question. I'll
Yes,
put
yes. Just put one
one
question.
Mrs. Banerjee, what is your educational qualification?
I'm a BCom graduate from Osmania University.
I'm become graduate from
Osmania University.
What did you do for your livelihood before getting married to the testator's son?
I was working with Standard Chartered Bank, working with the Standard Chartered Bank, both in Hyderabad as well as in Kolkata.
So I take it that Standard Chartered Bank was your only employer?
Primarily, yes.
When did you join the service of Standard Chartered Bank?
1992.
Service of Standard Chartered Bank. 1992.
February 10th, 1992.
And when did you quit the job?
I quit the job on 30th September 2011.
Well, let me
Okay.
those other.
Yes, record an order.
There are some corrections from the last day, my lord.
এই correction একবার একসঙ্গে করবো না? We'll
Yes.
learn reply you.
Advocates for the parties are present.
I'm indicating that there are certain
just
corrections
a
to be
minute.
made on 5th to the deposition on 5th August 2025.
DW1,
এইটা
MS Homi Banerjee is present in court.
There seems to be a disconnect.
DW1,
It is there.
MS Homi Banerjee is present in court. The examination in chief of DW1 is complete.
তুমি যখন বলে দিয়েছো ভাই।
The corrections, my lord, may be incorporated.
DW1, although is cross-examined in part, but cross-examination could not be completed, and thus she is discharged for the day.
না করে।
Yes, on
But
the prayer of the learned advocates.
can-
Anyway,
এই
let
correction, my
this
lord.
matter appear on
সেপ্টেম্বরে সেপ্টেম্বর
1 তারিখে দেখুন 2টোর সময় কি
হ্যাঁ?
3টের সময় আছে কিনা 1 তারিখে 2টোর সময় কি
সেপ্টেম্বর
1 তারিখে 4 PM ফিক্স আছে
একটু 4th
দুটো কি তিনটের সময়
4th or
কিছু নেই?
5th সেপ্টেম্বর ঠেললে হয় না? হ্যাঁ একটু পরে।
Yes, I'm keeping it at 3 PM on 1st of September.
No, Lordship will give me a bit of time because my witnesses are not stationed in Calcutta. If we come in the week starting from 8th.
আচ্ছা 8 তারিখে
পুজোর পর
8 তারিখে আছে কি 2টোর সময় তাহলে 8 তারিখ Yes, I'm keeping it at 2 PM on 8th 8/9
8 yes.
8th of September 2025. It is submitted by the learned advocates that some correction is to be made in the depositions of DW1. Let the rectification be made on the basis of the draft submitted by the learned advocates.
No, so far the corrections we have yet to reply it back. Lordship will not record that. We will do it in the next day.
No, I'm
The
recording
correction-
on the basis of the draft submitted.
No. The
Very
draft-
well, my lord. The
draft-
correction can be made on the next occasion.
The corrections can because
So I'm not recording that order.
yes,
Correction order
the last part the
last partটা কেটে দিন তাহলে হ্যাঁ ওটা কেটে দিন হ্যাঁ ওটা কেটে দিন Yes, let this matter appear on 8/9/2025 at 2 PM.
এখানে কোন ঘরটা আমার পুলিশটা কোথায়? কত বড় জানো তো বলো তো
4 PM matter
কোনটা বলো
কল
না
করে
একটু।
দিন
Item number 10 and 11, my lord, Mr. Dashgupta is there, my junior, my lord. My lord,
Yeah.
I was supposed to deliver the judgment, my lord.
Let me pass the orders. So,
Yes.
yes, item number.
I have prepared the list of days as lordships.
Yes. Give it.
From filing of that until date.
Yes, 111 এর রেকর্ডটা দিন একটু। Yes, where is the examination of this attesting witness?
The lordship would recollect that we had, it's a non-contentious.
No. But that is why you see, in solemn form it is not required, but in the common form, just one affidavit is usually filed.
But that affidavit of attesting
Yes,
witness
yes,
is there,
yes.
it's on record.
Yes.
So
So why it is not filed? It
was filed long back with the,
Let me
it
see
has to be filed along with the application. for
affidavit of
contempt.
assets.
Yes, assets and the affidavit of the attesting witness.
That's the common practice before the original side, my lord. We have to file everything. And that's there on the record.
Let me see that.
Yes.
Filed together with the grant, application for grant of.
The affidavit of assets, affirmation of the attesting witnesses. Affidavit of assets is there.
Not in nine, yes.
So there is another affidavit.
That is, may I, Lord, if not.
Yes, please see.
Page. Attesting witness, will attesting witness. আরে ভাই ফাইলটা দাও না, ফাইলটা দাও দিলে কোথা থেকে পেলো, এখানে নেই, আমাকে দিতে লাগবে ফাইলটা। But kindly pass it over. I'll find that in the records and that I hand over it from the.
Okay, both 10 and 11 are passed over.
Yes, 5 minutes I'll find it out from the. Or Lordship can take other matters in the meantime.
Yes, 10 and 11 passed over.
Recordটা এদিকে দাও। No, sir. Well, if I, with your Lordship's permission, I'm just going through the records first. Side.
Yes, call the other matters.
33 Vijay Nathulal Sharma.
33 I am appearing. So far GA 19 is concerned, I am the petitioner in GA 19.
Lordship, I am for the plaintiff. I just prefer not today.
GA 19 is your application.
My
affidavits are complete.
Lordship, I am appearing on behalf of the plaintiff in the matter.
Well, GA 19 is my application in a partition suit. An order of a receiver be appointed in respect of 3 of the properties.
So let it be taken up on some other day.
Yes, can be. Not tomorrow, my lord, and let it be in the list on Friday or next week, whatever, my lord.
Okay.
Or Thursday.
Let this matter.
33. My lord, the reply be kept with the record.
Yes. Let this matter appear on
Thursday.
25/8/2025, Monday.
Monday. Tomorrow I will.
Under the same heading.
Yes. But the affidavit in reply.
Let the
GA
affidavit in reply filed be kept with the record.
In GA 19.
Yes, let the affidavit in opposition you have already filed.
Yes, the opposition they have not used. Mr. Mondal has used the opposition. The plaintiff has not used the opposition.
Let the affidavit in reply to GA 19 of 2024 filed be kept with the record and copy be served.
We have served. Copy already served.
Okay.
But only another.
Copy be served.
Number 6 in the matter.
But there are two applications which we have filed, GA 15 and 16.
25 তারিখ রাখছে সব 25 তারিখ সব রাখছে
I'll only indicate there is partition suit. The players which we have made are also, my lord.
I am supporting Mr. Bag so far yeah
We are asking for a receiver.
Anyway, let me take up Mr. Mitro's application on Monday.
it's all will be taken same press same press.
Okay.
But I was small request to you, not in this matter. The next matters in the list.
Yes, yes, I know that these are your matters. I know that.
Tomorrow post lunch, I am not available. With a professional reason, I am not available, not a personal. Because tomorrow is a chamber day.
Anyway, then
So
34
post lunch, I am not available.
then any 34 to 37.
36.
So take your chance in the first half.
Yes.
Or if you want, I can make it not this week.
No, I will till 1:15, 1:30. I'm in court. With second half.
Actually, tomorrow is a chamber day.
That is the reason. That is the reason.
And
Chamber.
Friday, you see
Rabbi,
only.
खुशी करो ना.
Okay, item
Thursday.
34.
It can be on Thursday in the list. 34. कल तो बुधवार.
34 to 36.
Yes, 34 to 36. Yes.
Okay, 34 to 36, not this week.
Milord, not this week, Milord. I will be in some difficulty because of my clientele instruction. Nothing, Milord. Mitro is
So
not
Mr.
there.
Mitro has not concluded his submissions.
Yes, I have not concluded.
He has not concluded.
So I'm making it not this week.
Friday.
But I was saying, let it be in the list. Of course, it's going to be understood that Mr. Mitro, if he's not there, then your lordship will, Milord, make it not this week.
There is the understanding.
Okay, then not today only. Let it remain in the list.
Yes, let it remain. But the understanding between the lawyers.
Surely, surely.
Milord, please proceed GA 15 and 16 also on Monday.
Yes, it's Monday
On
all
Monday.
together.
Entire matter on Monday.
Milord, item number 39.
Yes.
Milord,
Lord,
joint
for the
and
place-
dual matter, Milord.
Uh,
Mr. Dutt was leading me. He
Mr.
has
Kaur,
submitted.
senior advocate, is leading us in. We are for the plaintiff lordship.
Anyway, not this week.
My lord, can it be
Talks of
fixed on?
settlement is going on. Acha, item number
Lordship,
39. Order to record করুন তো।
Kindly.
কোনটা?
Order record করো তাকে September মাসে।
No,
Item
Lordship,
39.
can
For
it
the-
be fixed on 25th?
You are for the plaintiff.
Yes, lordship. Mr. Kaur is leading me.
No, no.
Senior
Only
advocate.
one thing. I was myself present in the talks of settlement which took place yesterday, last evening.
It's better I send it to
Lordship,
mediation.
settlement talk is neither here nor there. Settlement is
It's a very
proposed,
positive
but
talk. It's physically
lordship, kindly let me disagree. This talk is neither here nor there. Kindly let us argue on our application for occupational charges. Mr. Kaur will be
When
there
you
on
want-
25th.
Milord, what I can
20
say,
No, when do you want the matter to be taken up?
I want it to be taken up.
25th.
I want it to be taken up anytime in the first week of September because the talks of
Okay.
settlement has to take a proper
Yes, yes.
shape.
Learned advocates for the parties are present. Let this matter appear on 1/9/2025.
Lordship, any time may be fixed.
Let it remain in the list. Okay. If it is not taken up, I shall fix the time. 1/9.
Milord, if your lordship's list is permitting for a time, then I'm not standing in the way.
No, let it remain. Otherwise,
Very
it will
well.
cause difficulty.
It may block your lordship's time.
Yes.
I completely understand.
Grateful.
My lord, I guess, my lord, item number 10 and 11 can be taken up. The affidavit of Dr. Joyanto Basu, affirmed on 18th day of April 2012, is already on record. I suppose Mr. Dasgupta can help it out.
But yes, I've already
Joyanto Basu.
with the document. Kindly, my lord, lordship would peruse that. I have handed over.
Yes, record and order. Learned advocate for the petitioner, executor is present. This is an application for grant of probate of the last will and testament dated 21st February 1997 of the deceased Pashupati Nath Banerjee. Stop. It is the contention of the petitioner that the deceased during his lifetime has made and published a last will and testament dated 21st February 1997. Stop. The said will was registered with the Register of Assurances, Calcutta on 21st February 1997. Stop. The deceased at the time of his death, the deceased was married to one Jhonna Banerjee, and the said Jhonna Banerjee died on 29th March 2009, being mother of the legal representatives of the deceased. Stop. Just a minute, the deceased. Yeah. Yes, when did the deceased die? Testator die? Which paragraph?
Which paragraph? That's 17th of March 2009.
Which paragraph?
First, it should be there in the first paragraph of the application for grant of probate.
Okay, the deceased died on 12th August 2009, leaving behind Mr. Swaraj Kumar Banerjee, Mrs. Rachna Chatterjee, and MS Ananya Banerjee. Stop. Mr. Swaraj Kumar Banerjee, Mrs. Rachna Chatterjee, and MS Ananya Banerjee. ঠিক আছে?
But deceased died on 17th of March 2009.
Yes.
Deceased died on 17th of March 2009. The testator.
It is stated that copy of the death certificate dated, okay, died on, okay, the local deceased Pashupatinath Banerjee died on 17th March 2009.
Yes.
Pursuant to the date of the deceased, this application, Pashupatinath Banerjee, the deceased, died on 17th March 2009. ঠিক আছে? Pursuant to the death of the testator, this application for grant of probate is filed. Stop. As the sons and daughters of the deceased did not give any consent, the citation was issued. As none appeared, pursuant to the issuance of special citation, this case came under the heading of non-contentious cause. Yes, on which date the matter was held to be, was directed to appear as non-contentious?
But that specific direction is not there. So, the Lordship had asked once to appear as a non-contentious cause in the list, but it has not, there is no specific
no, regarding that citation, service of the citation.
No, that we have done, Millard. On 1st of October 2024, we took an application, Millard, thereafter.
So 1st of October, any report that?
Yes, report is there. The register original side, Millard, has published, has submitted a report. The sectional officer prepared a report on 11th of July 2024. Last page of my list of dates. That report is on record, Millard.
Okay, just let me see.
Thereafter, the register.
Last page of your list of dates.
Last page, page number 4. 2 reports from the section officer as well as the registrar in insolvency. 11th July and 25th July.
Okay. As the heirs of the testator did not appear pursuant to the issuance of citation, the matter was directed to appear under the heading non-contentious cause. Stop. The attesting witnesses, Dr. Jayanto Basu, has filed an affidavit stating that he was present at the time when the testator made his last will, and the signature appearing at the foot of the will as Pashupatinath Banerjee is the proper handwriting of the said deceased. Stop. It is further contended that in the presence of Dr. Jayanto Banerjee, Mrs. Shubhra Dash, Advocate High Court, Calcutta, the will was executed and Mrs. Shubhra Das and Mr. Manik Chandra Malakar also affixed their signatures on the will as attesting witnesses. There are 3 attesting witnesses.
The 3 attesting witnesses. That is at the will, my lord. Yes. Page number 29, Lordship would find.
Page number
29.
29. Upon hearing the learned advocates and upon perusing the deposition of Dr. Jayanto Basu, who was one of the attesting witnesses, it appears that the testator had testamentary capacity under Section 58 of the Indian Succession Act to execute the will. The will is also executed in accordance with the Section 63 of the Indian Succession Act, and one of the attesting witnesses has filed an affidavit as to the execution of the will. Thus, in the facts and circumstances, the probate of the will of Pashupati Nath Banerjee, since deceased, should be granted. Hence, the probate of the last will and testament dated 21st February 1997 of the deceased Pashupati Nath Banerjee is granted to the petitioner, namely M.S. Shopna Dotto. Stop. Let the probate be issued upon compliance of all necessary formalities.
Only one suggestion, my lord, if Lordship permits.
Yes.
The third last sentence, Lordship has said, my lord, the last will and testament of the deceased, my lord, Lordship had given that line. But if Lordship, it pleases to record the exact property which is being bequeathed by
whatever you have made in the prayer.
Very good. Very good.
That I have passed.
No issues. This is the usual formula. No problem. The next, my lord, the other one, my lord.
So I'll take it up tomorrow.
Very good, my lord.
Achha, tomorrow under the same heading. Okay. 4:15 p.m.
Only one thing, Lord, now that tomorrow, since I got an opportunity, let it appear in under the heading non-contentious cause, so that problem will also be solved. These there are
Mr. Dasgupta will request the court, probably the other matters which are appearing,
Those
same
are
can also.
next week. I can, if I can dispose tomorrow this matter, I shall take it up on the next week. So let it appear tomorrow under the heading non-contentious at 4 p.m.
PLA number 115 of 2010. That
Yes,
will
yes,
appear as at 4 o'clock tomorrow under the non-contentious.
My lord, one thing, my lord, I am
Grateful.
for item number 48, my lord. Maybe on Monday, my lord, actually, since Mr. Aniruddha is tomorrow afternoon, so my lord, I am praying, my lord, kindly come to Monday.
48.
48, my lord.
No, actually, in their presence, I have stated not today. Okay, tomorrow I shall adjourn it.
Oh, yes, yes.
Grateful.
না না ওটা তো আলাদা এটা তো যে অর্ডারটা করে দিলাম আর এটা হলো এটা জাস্ট আর কিছু অর্ডার করতে হবে না 11টা এটা কালকে থাকবে 4টের সময়